Hey everyone, this is Attorney Andre, and I want to talk to you about the Alec Baldwin case, the involuntary manslaughter case that was on the news 24/7. Whatever you're watching was on the news. Now, if you don't know, what happened was Alec Baldwin took a gun that he thought was a prop gun with prop bullets, fake bullets, pulled the trigger, and it killed someone. Involuntary manslaughter. So the judge in that case, throughout the prosecution's whole case, dismissed it with prejudice, and Alec Baldwin is free to go. And this happened in the middle of a jury trial. Let me tell you about what happened. In January 19, 2024, Baldwin was charged with involuntary manslaughter when he shot and killed Miss Hutchinson. I forgot her first name, Hutchinson, on the set of the movie Rust. And during any kind of litigation, whether it's civil, criminal, administrative, you have a process called discovery. Now, what's discovery? Discovery is an exchange of information. You ask, I sue you. You ask me for information, prove your case. I want to know requests for production of documents, a change in documents. I want to know answers under oath. I get to take depositions. You probably heard of this term depositions before. Well, it's more than depositions. It's an exchange of information. Now, in a criminal case, it's even more important. If you remember the show, My Cousin Vinny, the movie, My Cousin Vinny. Remember My Cousin Vinny? Joe Pesci, he's in this role. He's an attorney. He's representing two young kids that were charged with murder. And then he's like, I'm going to schmooze the prosecution and get the prosecution on my side. Well, they go out hunting or they go out to a cabin, and the prosecution calls his assistant, the prosecutor calls his assistant and says, send Joe Pesci all of the files. And he sends him all the files. And Joe Pesci comes home with a box full of documents. He tells his fiancée, look at this. I schmoozed him. He gave me all of this information. And then his fiancée says, you're a moron. What do you mean? He has to give it to you. It's called disclosure. It's called discovery. That's exactly what it is. It's disclosure. It's discovery. And if you don't do proper disclosure and you don't do proper discovery, the prosecution loses their case automatically in every single state, in every single jurisdiction. So what do we have here? We have a situation where Alec Baldwin's lawyers filed several motions to compel, motion to compel and motion for sanctions as it pertains to discovery violations, starting on June 26th and going on to July 12th on the third day of the trial. And that's the major date you want to think about. June 26th, Baldwin's lawyers filed a motion because they didn't get certain discovery. What did they didn't get? They didn't get expert reports, they didn't get a supplemental report, and they didn't get the actual brand of the bullets to inspect them. They didn't get to inspect the bullets. And that's the key to the prosecution's case. There was supplemental exhibits as well, supplemental expert reports. None of this stuff they got. So day 3 of the trial, the jury is hearing all of this argument, hearing testimony from cops, testimony from witnesses, testimony from everyone, cross-examination, direct examination. And it turns out you had a motion on day 3 that says, hey, listen, we still didn't get to inspect the bullets. We still didn't get to do our discovery. We still didn't get to do all of the things we needed to defend Mr. Baldwin. And he is sitting here defenseless. And the judge says, well, I'm going to order you to produce this information. And they don't. Not only do they not do it, makes matters worse, they put all of the evidence in another case number. And what does that mean? Cases are always assigned case numbers. That's how we identify them. That's how you will identify them. If these evidence is on a different case number, the prosecution can say, oh yeah, we produced all of the evidence. But it strikes me as odd because they're producing them in this case, but for some reason they didn't produce a pre-discovery because it was under a different case number. The prosecution knew that they did this. There was a whole evidentiary hearing. They knew that they did this. They wanted to do it. They wanted to suppress evidence. And what would otherwise be a genuinely interesting case turned into the judge sanctioning them and doing what's called a Brady instruction. And that's a particular kind of investigation that the judge will do that says, okay, I'm going to look at what was suppressed. Who did it benefit? Is it exculpatory? And if it is, then I'm going to throw out the whole entire case. If it's not, I can do other things, like I can give a limiting instruction. What's a limiting instruction? Let's assume you have a jury, 12 people, 6 people, doesn't matter. The judge can say, I'm instructing you to ignore this evidence. I'm instructing you to think about it this way, think about it that way. So it's how the judge instructs the jury to view the evidence. Now, some lawyers will say that's not good enough, Some lawyers will say juries listen to judges and that's good enough. Frankly, I don't think it's good enough. I never like this limiting instruction because juries will do whatever they do and say whatever they say or think whatever they think, regardless of what the judge is telling them in a limiting instruction. And then the jury has to figure out what are they limited to. It goes into a whole area of law whether it's not fair to the defendant, especially a criminal defendant, who has this evidence suppressed, hasn't been able to take discovery on it, hasn't been able to do his own investigations, hasn't been able to get his own expert or anything. So we have that situation. The judge did not give a limiting instruction. The judge chose to dismiss the case with prejudice and found that the evidence is favorable to Mr. Baldwin, found that there is no way that that the prosecution can cure it, and also found very clearly that the prosecution cannot remedy what it was going to do, and therefore dismissed the case and wrote a 21-page opinion. And if you're interested, I'm going to link it somewhere here, but it's going to be a 21-page opinion, 21-page order from the judge dismissing the case with prejudice. Let me know what you think. Do you think prosecutions to be held to a higher standard? Do you think that it's fair to throw out a case? Do you think maybe a limiting instruction would have been a better option? Let me know. Like, comment, subscribe. Let me know what you think. I'm so excited to hear from you. Talk to you later.